Just make sure that good to go. All right, looks like we're up and running. Okay, perfect. So make sure we have everyone checked in and not in the waiting room. Nobody in the waiting room. Okay, perfect. All right, well, let's get on the record. So we have a pre-hearing conference in two dockets. First one, 2620 CW 104, the application of the Village of Howard to construct a water main extension. And docket 2620 CW WI 100. What did I do here? Just a minute. Let's go off the record. There it is. All right, let's get back on here. So the second docket's 2620 WI 100, the application of the Village of Howard for authority to proceed with installation and within the boundaries of the town of Pittsfield. So my name is Michael Newmark, Administrative Law Judge for the PSC. Pre-hearing conferences, I think as most of you know, deal with following matters, identifying the parties, issues, schedule, and other facilitating matters. These cases here will be particularly interesting because we are going to run the schedules and the hearings simultaneously. So a little bit of a different trick here, but nothing we haven't done before in some previous dockets, a few of them anyway. We've managed to pull this off. Also, we are interested in combining the hearing and scheduling, timing of the scheduling with another docket. I don't have that before me either. Perhaps, Evan, you can just chime in and give us the docket for that one.
Give me 1 second. I'll remember the docket number off the top of my head.
Yeah.
I can grab it.
Your Honor, the docket number is 4890 CW 102.
Yep.
Okay, and that's the Village of Pulaski's application to fill in the sentence there.
Construct water main and related facilities.
Okay, perfect. All right, great. Yeah, so the I think when we do the rundown here, at least so let me just back up and say I only presented the pre-hearing conference in the first two dockets here, the Village of Howard dockets, because those are the only two right now that the commission has opened with a notice of proceeding. So I typically do not work on dockets until a notice of proceeding goes out, or notice of investigation. Until the commission officially opens, I don't take action on the docket. We're anticipating commission will open that docket. We also understand that the issues, as at least the staff and I view it, issues are intertwined, and it will benefit all involved, especially the commission, to have a record that's complete on all three angles here. We're using all three dockets as the vehicles to present the record and accumulate the evidence that we need in order to make all decisions in all three dockets. So having said that, since we have all the parties, as far as we know, parties are the same in all three dockets. We're anticipating that. There may be a nuance if new parties do intervene in the Pulaski docket, but we can handle that as well if need be. But the impetus is to have these cases run simultaneously in order to produce a complete record. So in order for discussion purposes, I'm actually going to just reduce this to the CW docket here, reduce the screen share. Because this docket, to my understanding, is the one docket so far that's been open that has a statutory deadline. So in terms of scheduling, we'll want to make sure we're scheduling is meeting that criteria. But before we go further, we should probably get appearances on the record. So why don't we do that now? And I'm just going to start at the top of our service list. So you'll notice that for the service list that I created was for both the Howard dockets, CW 104 and WI 100. I believe the parties will be the same. I think in my proposal, it is to admit the village of Pulaski into the WI docket. I know they've intervened in the CW docket, but just for purposes of getting the appearances on the record, we'll ignore any technical details there in case there are arguments against doing that. So let's just start with who represents the PSC.
Attorney Evan Whites appears on behalf of the PSC. Good afternoon, everyone.
All right, and the town of Pittsfield.
Good afternoon. This is Vanessa Wishart on behalf of the town of Pittsfield.
Okay, Village of Howard.
Callisto and Alex Peterson from Michael Best and Friedrich on behalf of the Village of Howard.
All right. And Village of Pulaski.
Good afternoon, Brian Cahill and Mark Bender appear on behalf of the village.
Okay.
Judge Newmark, this is Attorney Wishart. My apologies. Rick Manthe and Keith Dennis are also on the phone or on the Zoom for the town of Pittsfield.
Okay, thanks. So I did want to mention for the future, I think we can manage this pre-hearing conference, but I think Brian and Eric, your volume, your microphones are pretty low. So in the future for the rest of the proceeding, we'll need to address that. And, you know, you'll see in the facilitating matters order, there is actually some suggestions about hardware that will work for Zoom or, you know, other arrangements if you have tech people at your firm that can help you produce better audio input for the hearing. That'll be necessary. So, but anyway, let's continue. So yeah, well, I think we can just in the first instance, I did want to address, make sure we have agreement on the parties. So for the CW docket, Village of Howard, Town of Pittsfield, and Village of Pulaski all intervened and are the parties in the case. I believe that was already decided in an order for order on intervention request. So that's not quite an issue here. For the WI docket, though, we do have, I use the same list on purpose, like I mentioned before. Although the Village of Pulaski, my understanding is, has not intervened at this point. So I did intend to include them as a party. Did anyone have a comment on that?
Your Honor, this is Eric Callisto. I'll have no objection if Pulaski wants to intervene. I guess I question whether they can be brought into the case against their wishes. We're not going to object if they want to be a party in the case, but they've not intervened at this point, I assume, for reasons of their own choosing.
Okay, so any comment from the village?
We have no issue with being a party officially to the WI docket. We had not initially intervened solely because it's not within our jurisdiction. So we didn't know that we didn't view that we had a right, but there's no problem with us being in it from our perspective.
Okay, yeah, so I'll make you a party then, make the village a party. Yeah, and I unless it's necessary on an objection, I don't usually distinguish whether interventions is by right or by permission. It doesn't seem necessary, especially when intervention stipulated, but or at least not objected to. But if certainly is being permitted because I'm permitting it, so that's a good way of viewing that. Anyone else on that issue? No. Okay. So I don't think there was a problem with the issues list that I put in the WI docket. I noticed that Attorney White's did bring that to my attention later. So let's focus on the CW issues at this point. Fairly much our standard construction case, water construction case issues list. Are there any comments on that? No, okay, we're in agreement with that. Okay. And let's just move through the schedule on the CW case. So proposed schedule, any comments on the proposed schedule?
This is Attorney Wishart. We have a conflict with the proposed schedule. We have an expert who is going to be out of town from June 30th through July. Sorry, just pulling up my calendar. July 7th. So we have a conflict with both the SIR rebuttal testimony and the hearing date, the 2nd and the 9th.
Okay.
I had discussed with the parties offline some potential revisions to the calendar, but I think I haven't heard back whether my suggested dates work, but also I think there's some potential complications with depending on whether we're trying to run all 3 of these dockets simultaneously.
Okay, well, why don't we address that concern now as well before we get into the details of the dates?
Yes,
you-
Your
Yeah,
Honor.
I'm happy.
Go ahead,
Sorry, go ahead.
Eric.
I'm happy to start us off on that.
Sure.
So from my perspective, we have no objection on behalf of Howard to running the 2 Howard dockets simultaneously. And I'm sure we can come to agreement here, subject to the ALJ's approval on dates. On the Pulaski docket, as you noted, Your Honor, the case has not yet been deemed complete by staff. Provisionally, we have no objection to running that docket in tandem with the Howard CA dockets, but that is subject to our concern about when the docket's going to be deemed complete and our related concern about the ability to conduct discovery on Pulaski based upon what that complete record is. So we're not in a position to agree to that today until we see how the Pulaski docket proceeds based upon staff's continued review.
Yeah, I don't anticipate making a decision on that here, because like I noticed, we only did notice the pre-hearing conference for the first 2 dockets. It would be our intention to use the same schedule, but if it's not practical, it won't be. Maybe staff, if you can enlighten us as to how the progress of the Pulaski docket's looking.
Yeah, I think that certainly is kind of the trade-off when it comes to scheduling here, trying to schedule all 3 of these running together. I think the schedule as proposed with the hearing date on July 9th was kind of intended to give a bit more time on the front end of the schedule to address some of those concerns that Attorney Callisto pointed out as far as the Pulaski application being submitted and the need for discovery kind of on the front end before the hearing. Certainly, if the parties want to move the hearing date up into June, that's certainly feasible from staff's perspective. But there's kind of a compromise then in terms of it compresses that early period of time. I don't know with the deadlines in the Howard construction docket that we can go really much later than that week of July 9th in order to get the briefing done, unless the parties want a very short briefing schedule and the kind of discussion and of record and memo and everything that needs to be done by the statutory deadline. So to your question about the status of the Pulaski application, perhaps Attorney Cahill can speak more to that. At this point, we have not received a resubmittal. So really the last kind of determination was the incompleteness determination.
Okay. Okay, so Attorney Cahill, any comments on that?
Yeah, thank you, Your Honor. Robert E. Lee is the consultant who's worked on the application. They are preparing responses to the incompleteness determination as well as the supplemental requests. That said, however, one of the incompleteness determinations revolved around the archaeological review, section 106 review. That is going to sort of be the fly in the ointment for, I think, a simultaneous schedule for all three dockets, because as of right now, the Village of Pulaski has not yet received all responses from the consultants who have to do that reporting and do that field work. And they're waiting to get those in, review those. The village board will need to approve that work, likely in April at their next board meeting, which means that it's probably not till late spring before that section 106 archaeological review can be done and provided, and that a completeness determination can hopefully be obtained. So I just don't know, given the statutory deadline to resolve Howard's construction docket, I don't know how we can wedge these all three together.
Okay, so let me ask, is there anything else holding up the application update?
My understanding at this time is it's really just that archaeological review. That's going to be the thing that pushes out the completeness determination.
I see.
I'm sorry, the completeness. Did you say determination?
Determination, yeah.
Thank you.
So, Attorney Callisto, how concerned are you with not having the archaeological review in hand as we proceed?
You're on mute, Mr. Callisto.
Sorry. Ultimately, that's a staff concern more than our concern.
Okay.
I doubt, given my past practice, there's going to be a lot of discovery on that issue, but the other stuff that's outstanding is material.
Okay. So, I mean, I should note, maybe to be more clear, the notice of proceeding can issue before the completeness determination. So, I think in order to move things along, make people parties, have my activities proceed, that could happen before completeness. And if Pulaski was able to file everything else, but this delayed archaeological review, at least that information would be available for parties and staff to use in anticipation of this all working out as we move forward. So I would propose that we at least get all the information that we can as soon as possible from Pulaski as the applicant in its case, without except for the archaeological review, if that needs to take some extra time. But I would also, request that staff move the notice of proceeding along so that we can finalize, or at least advance the procedures in the village's case and get that going, rather than wait it out until there's a completeness determination. And then I think we'd probably be well behind the Howard schedule at that point. So there's a few balls up in the air there, but if we could get as much as we can get in terms of the application update from Pulaski, and then get the notice of proceeding going and out the door, at least we have a chance to proceed as intended. There is the issue. So I guess in terms of the application documents, Attorney Cahill, does that seem reasonable? Is that something that can occur on your end?
Yeah, my understanding is that the response and associated documents should be filed by the end of this week.
Okay. And Attorney Whites, any problems there with that proposal?
No, that certainly makes sense. I would just maybe suggest that in what the village does file, to just note what's going on with the archaeological review. sometimes I think there's a desktop review that could preliminarily be done, or and then just know what the further plans are, because perhaps staff can start looking at that then before even it's finalized.
Yeah, so if we can look forward to possibly getting a preliminary, although that might not be possible if the village has to approve something, but yeah, so I just asked the village to work with staff with that, if they can, if there is a preliminary draft that they can file in anticipation of the final analysis coming in later, that would be even more helpful. But yeah, like I do concur with Attorney Callisto that the archaeological review probably won't be what's a major contested piece of this case, at least among the parties present. So so let's try to do that. And then I guess the other outstanding matter then is the hearing date, the rebuttal date, the conflicts that we have there. And I know that staff was working to delay the end of the process as much as possible to include more time on the front end. So I guess what I heard from Attorney Wishart is that the witness for the town would not be available until the 7th of July, or would be returning on the 7th of July. I can, if we do have basically a 2-week window between the hearing date and the briefs, which is not unusual, but is not always given. That amount of time is not always given to that extent. So there may be some room to push the hearing date, advance that date further into July without changing the briefing schedule. Any comments on that? Maybe a hearing date on the 16th?
This is Attorney Wishart. I apologize. We have another witness who's out. We've got some complicating scheduling on our end. Another witness who's unavailable the week of the 15th.
Okay.
Your Honor, and this is Eric Callisto. To be clear, I've tried to. Attorney Wishart and I have talked about an alternative schedule.
Okay.
The dates that we have currently in the notice of pre-hearing conference work for my witnesses, but if we're going to change any hearing dates, I'm going to need to talk to my witnesses. I don't have full calendars. I've tried to get that here in the last day or two, but have not been able to.
All right. Well, so I guess when it comes to staff's perspective, the July 30th is that a set deadline for the final submission of briefs? We needed to change any dates. That's a hard set date in terms of the process, remaining process.
Yeah, I think there's maybe a small amount of wiggle room, but that really, with everything that needs to occur, doesn't leave a whole lot of room on kind of the back end of the schedule to get a decision issued by the statutory deadline. So,
Okay.
Getting back to
just refresh my memory, we already asked for an extension.
Correct. So September 23rd, I believe, if I recall correctly, is the statutory deadline for issuing a decision. Just in terms of, was it just the one witness, Attorney Wishart, that is unavailable on the 9th?
It's really more the rebuttal date that we have one witness who will be unavailable from June 30th until July 7th. So I'm not anticipating for that. I don't think that July 2nd rebuttal date would work. And I was anticipating that would require moving the hearing date then too, if we're trying to change that rebuttal date.
Perhaps I would just throw it out there for consideration. If that's the conflict, maybe we could move either the server rebuttal or server rebuttal and rebuttal, but leave the hearing date as is, if that works for everyone else.
Think there you got something there. So is there an issue with the rebuttal date? Or is it just the surrebuttal?
For us, just the rebuttal date.
Anyone else have a problem with the rebuttal date? So, I mean, we could push the hearing back a few days and then put the surrebuttal into like, well, we could do surrebuttal on the 9th and the hearing on the 11th or 12th. And then there's a problem with the 15th for the other witness, so that might solve our problem there.
Your Honor, I'm not available on the 11th or the 12th for the hearing.
Okay.
If we
Well-
keep the hearing on the 9th, can we just change the surrebuttal date to a date that we all agree on?
Well, I think the Pittsfield witness isn't available until the 8th. Is that for producing surrebuttal, right? Isn't that the issue?
Right.
So if the surrebuttal was filed on the 8th or 9th, we could have the hearing on the 10th.
Your Honor, my thinking, the reason I mentioned the rebuttal is
Yes.
potentially if we move the rebuttal up to give a little bit more time between rebuttal and server rebuttal, and then move the server rebuttal towards the end of June, but leave the hearing date on the 9th, because it seems like the hearing date will work for everyone.
Okay, and presumably discovery would already have taken place, at least for the direct rounds. So we'd be keeping enough time for that.
Your Honor, part of the issue when we agreed on these dates, as we talked about them, part of the issue was to allow for discovery after rebuttal. And I believe the standing order is still 21 days, if that's correct.
I
can't remember if it changes.
After
I'm sorry,
rebuttal, it does change, I think, and we could change, if that's an issue, just getting the response deadline, we could accommodate it that way too, but my understanding is we do change that after rebuttal.
My concern is more the time after the current May 22nd date, to allow adequate discovery by us then, based upon what we see in testimony. And recognizing that although we're not talking about it today, if the Pulaski docket catches up to these two, there's going to be filing obligations of every party on every one of these deadlines, either in these two cases or in the Pulaski case.
Yes. So we do have a 7-day deadline after rebuttal is filed to respond to discovery. So just showing that on the screen here. I don't know if that helps your issue quite enough, but
yeah, again, it's not the 7-day after rebuttal; it's the 21 days between.
The two directs. I see what you're saying.
It's actually the 21 days after May 22nd, because that presumably is when Pittsfield and Pulaski and staff will all be filing their testimony.
Your Honor, this is Alex Peterson. Would it make sense to move up the surrebuttal date to Friday, June 28th? I think it's only a couple days before the current date, July 2nd, and the Pittsfield witness would be available at that time. I don't know if that makes sense.
Yeah, I think that would work from our perspective.
Okay. So surrebuttal June 28th. All right, is that all we need to do then? Was it that simple, or is there another?
I had wanted, I'm the complicating factor in this. I had one additional request. I will actually be on vacation from July 23rd to the 30th. Would it be possible to move the reply brief date back to August 2nd instead of July 30th?
Well, what do you think, Attorney Whites? I think we just decided that was a pretty fixed date, so the 30th to the 2nd, is that going to be? That's a number of days there.
That'd be a Tuesday to Friday.
Yeah.
I was gonna say, I think the 2nd is a Friday. I mean, it certainly shortens everything, but I guess in terms of making things work, it would potentially be doable. What were the dates that you were out, Attorney Wishart?
The 23rd through the 30th.
Okay, so it's not like moving it forward would really help then.
Right.
Trial that week too, so a few extra days at the back end would not make me sad.
So I guess it's really if staff has enough time, we would be doing a decision matrix in the case, and there's going to be potentially quite a few issues, right? If we have 3 to deal with, so
Even if we could do August 1st, just so that I'm back for a day before that needs to be filed.
And actually, I mean, maybe if staff can also, no, I guess I don't want to complicate things more. So, okay, yeah. So I'm sorry, Attorney Wishart, could you repeat what you said?
I just said even if we could do August 1st instead of August 2nd, just so that I would be back for, you know, a day to before that's due.
I think that's fine. That probably is an adequate compromise.
Okay. So do we still have an issue with the discovery interval between May 22nd and June 21st?
No, that's okay, Your Honor. I was going to suggest, because that's a 21-day period. The one thing I would ask, I don't typically do discovery between rebuttal and surrebuttal. As you noted, it's 7 days.
Mhm.
If we could knock that down to 3 business days after rebuttal is filed, or excuse me, 3 business days after discovery is served between rebuttal and surrebuttal, that would at least provide the opportunity for discovery. I recognize that that's challenging turnaround time. I note that it's 5 days in Iowa on a regular basis, which is challenging, but I would certainly work with opposing counsel if we made a discovery demand after rebuttal is filed to keep it tight and work with them on a response date.
Okay. Any comments there?
There's no objection to that.
No objection for me either.
And so just to recap, the hearing remains, hearing will be, that we're keeping the hearing date, the 9th. Okay, so that's, and surrebuttal June 28th. And reducing the response to a request for discovery filed after rebuttal to 3 working days. Getting those right? And anything else I missed there?
Did we change the reply brief to 8-1?
That's right. Brief to, yes, reply brief to 8-1. Okay. All right, so we'll make it so. That'll work. So let's just recap here.
Judge Newberg, I apologize. Can I ask one question? Is the plan to have the hearing in person or virtually?
Well, yeah, okay, so I originally thought in person would be really necessary in this case because I wasn't seeing the full picture with how Pulaski fit into the process. And then I think after reading some of the responses to data requests, I understood more. So I don't necessarily have a preference at this point. I think if we can get all the parties together and get everything, get what we usually do, get the majority of testimony in writing, no physical location would work. But I don't have any problem with meeting in person. If there's someone wishes to request that, give me a reason for that, that's fine. So if there's a preference for meeting together, that's fine. But we can still, doing it by Zoom only is also okay with me. So does anyone have a preference?
Not at this point, Your Honor. Vanessa, would you prefer an in-person or would you prefer virtual at this point, recognizing
I don't have a
not
preference.
asking a committee?
I don't have a preference at this point. I have not done a hearing in a little while, so I just wasn't sure what staff is doing now.
Right. I mean, in my theory generally is if I see that there's a need for it, I think essentially if we really think that the facts will not be elicited through written testimony, that there's something we need to see in person and gauge a witness's credibility in person, that would be I would most likely just require we meet. Otherwise, if a party requests it, I really don't see a reason not to do it. But on the other hand, I know we've enjoyed the convenience of Zoom hearings, and they seem to work just fine, especially with the way our process runs. So if people are willing to trade off maybe some issues with the technology for the convenience, I'm willing to go with that. So it's kind of an open-ended issue. You can just take it case by case as we go forward.
Okay, that's fine with me. Thank you.
Okay. So that's good to point out while we discuss the schedule it sounds like we'll do the hearing Zoom only. So I think before we get to facilitating matters, we should switch to the WI docket and deal with my inconsistent or too much consistency here with my cut and pasting on these two different dockets. Just goes to show you the unique challenges we may face in this case, in this group of cases. So we just want to be careful to know what documents we're filing where. So the issues apparently, obviously are not going to be the ones here displayed here for the WI docket. I know staff did have a proposed set of issues. I don't know if Attorney Whites, if you had shared those with parties in light of my error here, and if parties have comments on those.
Your Honor, the parties proposed some language that was largely in line with what staff was originally going to propose. I think the only issue that I did not hear back from the parties on was whether or not to include two sub-issues. So I don't know if any of the attorneys here this afternoon have a preference on that.
Yeah, this is Eric Callisto, Your Honor. I don't know that the sub-issues respectfully are necessary. I think they're captured in the framing of the issue as we proposed it and as corrected by Attorney Wishart. And I'm happy to read that out if that helps.
Yeah, if we have what's being agreed to by parties, if you could read that into the record, appreciate it.
Sure, I'll read it and then wait to hear from others. Quote, pursuant to WIS Stat Section 196.58 sub 7 sub A, comma, should the commission find that it is necessary or economically prudent for the Village of Howard to install the proposed project within the boundaries of the town of Pittsfield to serve the Village of Howard's consumers, comma, and if so, comma, under what terms and conditions, question mark.
Okay. So, any comments on that?
This is Attorney Wishart. We're in agreement with that language. We're fine with the sub issues proposed by staff, but don't feel strongly on including those or just limiting it to the language that Attorney Callisto just read.
Okay. So Attorney Whites, if you want to read those sub issues in, if you feel like you want to press those, or we can leave it as is.
Your Honor, I'm fine if the parties prefer to just leave it as is. I think really it's somewhat redundant, but just spells out the two questions that the commission would be looking at. Number one, whether or not it's, now I'm blanking on the language, necessary or the language that Attorney Callisto read, the first question, and then the second question as far as the if so, under what conditions. I think there was just a slight change to that language to say in what manner, because that's also something that's referenced in the statute, that the commission may specify the manner for the installation. I can certainly read what I had sent if that would be helpful, but if the parties don't want those additional sub-issues, I don't necessarily need to do that.
Okay, well, why don't we leave it as is? I think we did cite the statute, so I think we will be able to follow the authority given within the the four corners of the text. So whether we put manner in the issues or not, I think everyone understands they'll be subsumed into what was read in. Okay. So issues there, and so schedule in the WI will mimic what we just decided in the CW docket. And for facilitating matters, this facilitating matters document that we've attached to the notice. I could strip the date from there. I think it should be from a January 16th iteration of this document. So if you've worked on that before, it should be the same. I think like I said, we'll need to be careful about naming conventions and page numbering for making sure we're filing items in the right dockets. But I just want to emphasize, it may be helpful to note the tables here that do give you examples of how to name page numbers and testimony, and also the file name or the IRF document description that you'd want to input. Same thing for exhibits. This is the IRF document description for testimony. And then this describes the exhibit naming convention. And I think we all understand there's going to be a lot of filings done. If they're not filed correctly, we'll have a refiling. So to limit that as much as possible, make sure you double check the FMO or contact commission staff. I put Attorney White's on the spot here. And if he doesn't know the answer, he can relay the question to me. But it's better to be safe than sorry. It's quite a bit of work getting these filings, preparing these filings, but it's also work checking that we've met the standards and requesting refiling as well. So appreciate what we can do to prevent that. And so there is a nuance here for people who haven't practiced this year. That is, we used to require that hyperlinks placed in testimony and exhibits be disabled or redacted. We're no longer doing that. We're hopefully this is a way to be more efficient and having less work preparing these filings. But you'll see in the standards for content of testimony and exhibits, there's a new process where you just disclaim that the whatever hyperlink or any citation you're citing to, but not offering for the record, there's a disclaimer saying this is not being offered for record evidence. So there's always this tension between putting in a citation just so parties know where the information's coming from, what's the basis of the testimony, but not needing that document in the record. I just want to end make sure we have no confusion about that when we go down the line. Instead of dismantling the link or disabling the link, just putting a disclaimer saying it's not being offered for record evidence cures that without a lot of maybe technical issues trying to correct and reformat documents. So can't find it here exactly, but so for exhibits, the innovation is if you're producing a document, say like a published article, which almost always has hyperlinks in it, you need only put a disclaimer on the cover page that says links in here are not record evidence. There's actually specific text you can use that's in the FMO. And that just inoculates the whole document. So you don't have to go through the work of changing those links throughout. And then for testimony, it's putting, probably best thing to do would be put it in a footnote that the link being used is not record evidence. That's how we'll curing that issue from now on, at least in this instance of our process. Otherwise, I think it's fairly the same. We are trying to make some more innovations here, but they're not reflected in this version. If you have any questions, contact the attorney first, and I'll be able to back that up if necessary with an answer. So appreciate being proactive on that. So,
Your Honor.
Yes.
One question with if the schedule does end up being consolidated, would it be your intention that on April 23rd, Pulaski would have to file its direct testimony? Because I don't know if we're going to be ready in essentially a month to have direct.
Okay, that was the hope. Yes.
Okay.
So yes.
I think hearing from so Attorney Bender has been the one working most closely with the consultants, and he has a serious concern about that deadline. Once we realized that, and we had originally thought that our first testimony would go in May 22nd. I don't know that the 23rd is realistic, given that they're still working on getting the application complete.
Okay. Well, yeah, I mean, we haven't set the schedule in the Pulaski case yet, so I mean, nothing is certain. And yeah, I mean, maybe it's just a pipe dream to do it this way and the way these cases are lining up. But I guess we'll just keep that as the intention, the aspiration. But yeah, I think we all recognize that we've sort of have a binary decision-making situation here. I mean, maybe this is something we should discuss. That's my view of the case, that we have sort of a binary kind of a, yes, Howard, no. I mean, essentially the decision would be no to the Pulaski project if we're saying yes to the Howard project, or actually maybe it's more vice versa. If we're going to if the commission does approve the Pulaski project, does that not create issues for Howard? And that's why having this all in one presentation gives the commission the opportunity to decide these all together without having. I mean, I guess it could just reopen the case and change its decision in one if that comes later, came before. So there might be a opportunity there, but I guess I don't want to corner the commission in when we have pending dockets at least. It's just a matter of timing rather than a matter of substance, preventing the commission from seeing the full picture.
I don't know that it's necessarily a binary, but still evaluating that. I don't think it has to be binary. It may be
Okay.
double yeses with conditions.
Right. There could always be conditions, I'm sure. Yeah. Yeah.
Yeah, I agree with that, with Brian's conclusion on that, Your Honor. I think, at least for the moment, it may not be a binary choice.
Okay. Any view from staff on that? Or let me ask Pittsfield first, if you had a comment first before you staff.
I think it's possible that it could be non-binary with, as was mentioned, with conditions imposed.
I guess from staff's perspective, based on what's been filed, I think it's not necessarily for sure a binary decision, but I think practically speaking, just looking at what the applicants have stated as far as some of the considerations for why they're requesting each of the two proposed projects, there certainly is some degree of overlap there, such that a commission decision on one project would necessitate probably a determination in the other project. So it's not as if these can necessarily, from staff's perspective, be split apart into two separate projects. I think that there is considerable overlap, not only in terms of the route, but also just in terms of some of the presentation of evidence and statement as far as the need for the projects.
All right. Well, I think so. I mean, we can just leave it as our aspiration, our intention to run these simultaneously, and we'll have to look at how it practically shakes out. I mean, at this point, Pulaski is the controller of the information it has in its project. Hopefully, it could, start working and on the case documents, on the testimony, gathering information for that purpose, maybe fill in the blanks as you get closer to the deadline. So being more sort of proactive on that, and maybe a little innovative to try to draft things in anticipation of meeting that deadline, with the understanding that, not all the information may be available while you're working on it. It could be that we do some sort of supplemental round as well, in that case, if necessary. But this is a tricky schedule, so we'll have to kind of see how this shakes out. So yeah, I guess and I think in that sense, given those realities, I think we'll most likely need some sort of pre-hearing conference in the Pulaski docket once we get a notice of proceeding out, and maybe get further on in the process, just to double check. So rather than ordering, just a copy of what we're seeing here as the scheduling order in Pulaski, it doesn't look like we have agreement for that yet, or it doesn't seem to be practically perfect yet. So I think I'll just hold off on ordering the schedule in Pulaski, and we'll most likely need to meet again. And perhaps we can get a stipulation, but we'll see how that goes. So yeah, like we started, we're only dealing with the Howard dockets in this pre-hearing conference, and we will try to align the Pulaski hearing as best as possible when we get to that point.
Attorney Cahill, I think you said that Pulaski anticipates filing the supplemental responses by the end of this week. Was that what I heard correctly?
That's what I understand. They're gonna try to get them. Robert E. Lee is supposed to try to get us drafts this week, and then hopefully we can turn them around and get them on file promptly, assuming they're in good shape. But I haven't had a chance to see those yet.
Okay. And then the only reason I mention that is hopefully then we can maybe address this in the next week or two so that everyone we have a schedule. But I at least from my perspective, I would encourage that every effort be made to try to because there's a lot of moving pieces, and to try to make this all work together. If we can stick to this schedule as proposed, that would certainly be the best, I think, for everyone.
I understand.
All right. So any other matters we need to discuss before we adjourn?
Your Honor, Eric Callisto, just one question. I don't believe I've been at a hearing where we've conducted a hearing simultaneously for 2 and maybe 3 cases here. Do you have a sense of how that will proceed? That is, will it be each case sequentially, or will you swear in witnesses and have them crossed on both cases at the same time?
Good question.
Oh, and maybe there's not an answer at this point. I just wanted to throw it out there early.
Yes, I appreciate that. Yeah, I mean, I can take comments on that if people want to think about it, but you know, because bulk of our testimony is dealt with in writing, it may be more conducive to efficiency to just call a witness once and then have them be subject to cross on all corners of the different cases and at one time. And you know, I think, like, as we understand, these cases are intertwined to a great extent, you know, regardless of maybe conditions that might be issued. And I guess so I guess having the testimony, as long as it's in the record, I guess it doesn't matter too much to me. But just to have the calling the witness once may be most conducive to efficiency. And I guess just to think a little bit more about that, I suppose the conditions themselves have a substantial evidence to base the conditions that may make this whole thing work. They may need to be in all dockets, in the record of all dockets. So so even though the cases may not be a binary decision, the record on the conditions or reasons for the conditions may need to also be presented in all 3 cases. So there is some tension there as to making sure we can get these cases lined up. I guess there are other alternatives. I guess the worst case scenarios, we could adopt some, or, you know, enter some of the record in one case into another, just for consistency. But I don't know if it's not an ideal way to handle things. So let's
Thank you.
There, yeah. Okay.
Yeah, and I'll talk to the other parties, see if we can come to an agreement that maybe we can put in front of you on that, if that makes sense.
Okay. All right. So anything else? Anything on the facilitating matters? Other questions or comments? No? All right. Yep. That's it. All right. So thanks very much, everyone. I think we will definitely see scheduling orders for the WI and the Howard WI and CW dockets issued in the near future. In the meantime, let's use the schedule we have agreed to at today at the hearing, and you can use the transcript as a reference if you need to. All right.
I have one clarifying question. My assumption is that we will continue to file, even if the testimony is entirely duplicative in the 2 dockets, we will file separately in both dockets.
Yes, thanks for mentioning that. Yeah,
Okay.
You just want to change the docket title and the page numbering convention, although that might not change. docket title would change
Right.
and where you're filing it. Yeah, that's where the trick is. Just make sure you're getting it all into the right place at the right time. Yeah.
Right. Okay. Thank you for that clarification.
Yeah. Okay. Anything else? All right. Well, thanks very much. Thanks for being flexible as we innovate. That's what we like to do around here. So appreciate your patience with that. All right. Well, take care. We're adjourned.
Thank you.
Thank you.